By the end of this chapter, students will be able to comprehend the provisions relating to the appointment of directors, number of directors, resident director, appointment of woman director and others. Explain the director identification number, its allotment, and other matters relating to DIN. Elaborate as to who are independent directors, their appointment, qualifications, tenure etc. Specify and recognize the provisions relating to the first director, additional director, alternate director, nominee director, and casual vacancy of the director. Explain the provisions relating to small shareholders director, retirement by rotation, principle of proportional representation for appointment, maximum directorships etc. Describe the disqualifications pertaining to the appointment as director, duties of directors, vacation of office of director, resignation of director, removal of director, etc. According to Section 210 of the Companies Act 2013, Board of Directors or Board, in relation to a company, means the collective body of the directors of the company. Now let me explain you what is director. According to Section 234, director means a director appointed to the board of a company. The directors are the individuals who are appointed to manage the business affairs of a company. So now, what is company? A company is an artificial person created by law, having separate legal existence, but without any physical body or mind of its own. It needs to be managed through the human beings. Though the shareholders being owners are physically available to manage their company, but as their number grows, all of them together may not be able to manage the affairs, and if they do so, it shall be mismanagement and nothing else. That's why the concept of directors has emerged. The directors, within the permissible limit, may be elected from among the shareholders or outsiders. As regards legal position of directors in relation to a company, they can be considered both agents and trustees. As agents, they bind the company as their principal as soon as they enter into various transactions on its behalf. The law of agency comes into play and it governs the relationship between the company and its directors. At times, the company itself is principal as well as agent in respect of certain acts which cannot be delegated. The Companies Act 2013 lays down provisions requiring as to when the company needs to act both as principal as well as agent and when the directors need to act as agent of the company. It may be noted that where directors are empowered to take certain decisions, the company cannot negate them, or issue directions to the directors, directing them to go for a particular decision, except that it may replace the directors with the one of its choice. As trustees, the directors are required to take care of properties, monies, trade secrets, etc., and belonging to the company. In fact, as trustees the directors are in a fiduciary relationship with the company, and not with any individual shareholder, and if such relationship is broken and the company suffers losses because of the illegal acts of the directors, the erring directors will be required to compensate the losses suffered by the company. The office of directorship is an office of trust. Definition of directors as officer. The definition of officer given in Section 259 of the Companies Act 2013, inter alia, includes director, which means a director, at certain times, is also the officer of the company. Since an officer is an employee of the company, the director as officer is also an employee as far as certain provisions of the Companies Act 2013 are concerned. The collective body of the directors is called the Board of Directors, or simply the Board. It is the Board which takes decisions at its meetings, and not any individual director. This is the reason why a quorum, means presence of minimum directors at the board meetings, is prescribed so that collective decisions are taken. At times, if permitted, the decisions can be taken by the board, without calling a meeting, but in that case too, they are collective decisions. Section 149 of the Act contains provisions which require that every company shall have to constitute Board of Directors. The provisions of Constitution of Board of Directors are stated as under. According to Section 149, 1, of the Companies Act 2013, every company shall have a board of directors consisting of individuals as directors. Thus, any person, other than individuals, like a body corporate, firm or association of persons cannot be appointed as a director. Every company shall have minimum number of directors as mentioned below. In case of a public company, 3 directors. In case of a private company, 2 directors. And in case of a one-person company, 1 director. Maximum number of directors can be 15 directors. Note, if the company wants to appoint more than 15 directors, it can do so after passing a special resolution. A government company is exempted from the application of Section 149, 1b, which requires a company to have a maximum of 15 directors only. And from the application of first provision to Section 149, 1, which enables a company to appoint more than 15 directors after passing a special resolution. However, above exemption is applicable only if such government company has not committed a default in filing its financial statements under Section 137, or annual return under Section 92 with the registrar. Similar exemption as above is also applicable to company incorporated under Section 8 of the Companies Act 2013, subject to the condition that such a company has not committed a default in filing its financial statements under Section 137 or annual return under Section 92 with the registrar. Woman Director. At least 1 woman director shall be on the board of such class or classes of companies, as has been prescribed in Rule 3 of the Companies Rules 2014, which is, Appointment and Qualifications of Directors, as per second proviso to Section 149, 1. Rule 3 provides that, the following classes of companies shall appoint at least 1 woman director. Every listed company. Every other public company having paid up share capital of 100 crore or more, or turnover of 300 crore or more. For the purposes of having a woman director on the board, it is clarified that the paid-up share capital or turnover, as the case may be, as on the last date of latest audited financial statements shall be taken into account. Compliance by a newly incorporated company. A company, which has been incorporated under the Act and is covered by the provisions requiring appointment of a woman director, shall comply with such provisions within a period of 6 months from the date of its incorporation. Filling of intermittent vacancy of woman director. Any intermittent vacancy of a woman director shall be filled up by the board, at the earliest but not later than immediate next board meeting, or 3 months from the date of such vacancy, whichever is later. For example, Sheetal was occupying the office of woman director in a company, but due to her sudden death on March 17, 2019, the intermittent vacancy was required to be filled up at the earliest, because she was the only woman director on the board. The immediate board meeting was held on June 25, 2019. The vacancy of the women director must be filled up latest by June 25, 2019, or within 3 months from the date of such vacancy, which would be June 16, 2019, whichever is later, means it should be filled up by June 25, 2019. Other types of directors. Resident director. Every company shall have at least 1 director, who stays in India for a total period of not less than 182 days during the financial year. However, in case of a newly incorporated company, the compliance requirement shall apply proportionately at the end of the financial year in which it is incorporated as per Section 149, 3. Independent director. Specified public companies are required to appoint independent directors on their board, with a view to boost the level of corporate governance. Such specified companies are the backbone of any economy and therefore, they must be managed in the best possible manner, including adhering to the specified legal provisions. An independent director needs to have an independent mindset, which should not be unduly influenced by the other members of the board, and if such members take any decision which is illegal or not in the best interest of the company, or economy, it must be hindered by the independent directors at the outset. The provisions relating to independent directors are discussed later in the chapter. Interested director. An interested director is one among the other directors who constitute board of directors. In fact, when an existing director becomes interested in a transaction of the company, he is called interested director, and he needs to disclose his interest at the appropriate forum and at appropriate time. The provisions regarding interested director are discussed in another chapter. Executive and non-executive directors. The board of directors may comprise both executive and non-executive directors. The executive directors are responsible for managing different business operations undertaken by the company. It is their responsibility that the departments which they head operate smoothly. A whole-time director and managing director are covered in this category of directors. In contrast, the non-executive directors participate through board meetings, in discussions relating to framing of policies for the efficient management of the company. Professional directors and nominee directors are covered in this category of directors. Independent directors are a type of non-executive directors. They are not as active as executive directors on the board of the company. They are held to be liable only if they knowingly consented to the wrongful acts.